Divorce can be a strenuous, confusing, and anxiety-ridden affair, especially when children are involved. Family law courts are there to ease the transition to divorce for spouses and children.
Family law is any area dealing with marriage, divorce, or the relationships between parents and their children. So, as a board-certified family law specialist, I'm certified to be a specialist in premarital property agreements, divorce, adoption, paternity suits, anything dealing with that relationship.
In the past, divorce was not readily available nor readily accepted. This forced parents to have difficult separations with no proper support. Sometimes a parent had no effective way of being involved in their children's lives after a divorce. This was traumatizing to the children.
I think everybody knows that the best way for children to be raised is if you have two parents that fall in love, they have children, they stay together, and they raise those children together. Unfortunately, that doesn't work for every family. When divorce was hard to get, what you saw was families struggling without any hard guidelines as to how those children would be raised and how both parents would remain involved in their children's lives. Family law courts are here to help the parents resolve those issues and lay down some boundaries for the best interests of the children. Here in Texas, we are really fortunate in that our judges are experts. Most of the judges that hear family law cases in Texas, that's all they hear. And one of the things that our judges have learned is that families work best when they're able to come to an agreement. So in order to encourage families to reach an agreement outside of the courtroom, most of our judges will require the parties to go to mediation before going to court and see what they can work out on their own. For most of the mediations here in Texas, both of the parties are still going to have their own attorneys helping to make sure that their interests are protected. Sometimes the mediator is a retired judge, sometimes it's another family law attorney that everybody involved can respect. We really want to make this process as comfortable on the clients as possible, and experience has taught us it's usually best to keep the parties apart. Property split can be a big area of disagreement, especially where there's a family-owned business. We handle a lot of those here at the Bolton Law firm. The number one priority of the family law courts has always been the best interests of the children. And that should be the number one priority of the attorneys that are involved as well. What the court is supposed to be focused on is what is in the best interest of those children.
Today, there are some very vocal groups pushing for a 50-50 parenting schedule to be imposed on families by the courts. Right now, only 2 states begin with a presumption that children should split their time exactly evenly between 2 households. But similar laws are being debated all across the country. In Texas, a similar bill, HB 3379, was recently defeated.
We see every legislative session now a law being brought in place to try to force judges to assume that children should spend 50% of their time in each household. What you're going to hear them arguing is, what is fair for the parents? How can we make sure that the parents are exactly equal? And that's taking the focus away from what's best for the children. In my 27 years as a family law attorney, I have spoken with hundreds of parents about why they might want a 50-50 parenting schedule. There are 4 big reasons that I hear. Number 1, they don't want to pay child support. Number 2, they want to prove that they're just as important as the other parent is. They're doing it to protect their rights and their involvement. The third most common reason is when actually dad has been the primary caretaker of the children, and mom can't face the stigma of losing custody. So the fourth reason that people come in asking about a 50-50 parenting schedule is the very best reason of all, and unfortunately, it's not one that I hear very often. And that is because both of the parents have been deeply, actively involved in raising the children while they were together. And they can work together well enough after their separation or divorce to continue making decisions together.
The days when divorce meant that one parent lost all rights over a child are over. Most states enforce generous visitation laws and assume that both parents should continue to have rights to be involved in the educational and medical decisions made for children and to be heavily involved in their moral growth and development. 34 states, including Texas, are considered shared parenting states, meaning that the children will spend at least 1/3 of their time with the parent that they don't live with.
The laws in Texas have already changed, and that's a good thing. So the laws that we have right now are designed to make sure that both parents can continue to be involved in their children's lives. We call that joint managing conservatorship. And all that means is that it doesn't matter who the children live with. Both parents have a right to talk to the teachers. Both parents have a right to talk to the doctors. Both parents have a right to be appraised of every significant development in that child's life. Over 80% of the time, the parents come to an agreement on what's the best arrangements for their child. And the court doesn't need to get involved at all. The court makes a ruling only in those 20% of the cases where the parents just can't agree. My children are 27, 25, 23, 21, and my youngest just graduated from high school. I love children. I don't just say that, they are the focus of my life. And they're the focus of my practice as well.
The lawyers at Bolton Law don't just do family law sometimes. It's all we do. Our attorneys are experienced, dedicated professionals, skilled in helping parents protect their children's best interests and in preserving the marital estate. For assistance and information on family law, visit www.boltonlaw.com.